Judge DeLaO again. This is Ben Hitchcock Cross talking to you today for Deliberate Indifference, Wisconsin. I have here my brief in the Novak case. Bam, and like that. It's not short. Anyways, I'm going to read out some selected parts here, particularly with the argument against why Judge DeLaO should not have heard that case or made a decision. She should. The way it works is this: the judge has an independent attorney working for the governor, has the duty to remove themselves if there's a conflict that they're aware about. That's an obligation on them as an attorney and then also as an ALJ. There is a procedure where a party, a complainant or a respondent, can make a motion to have the judge remove themselves, but that's only within the decision of, again, the attorney working for the state or judge, which is, I want to be clear, a circuit court judge, a justice of the Supreme Court, is also an attorney working for the state. It's just that they are a member of the judicial branch, as this attorney is a member of the judicial branch working for the governor. So one works for the state of Wisconsin. That's the difference, the judges. And I don't care who signs their paycheck. Believe me, the governor, in my understanding and experience, is not telling the judges or certainly the Supreme Court what to do. I don't think even the Supreme Court is telling, in Wisconsin at the current moment, is telling the Supreme Court what to do. So that being the case, that's different as opposed to this is a person whose direct supervisor is an appointee of the governor of the state of Wisconsin. Different, completely different scenario. The person whose paycheck signs, the judge's paycheck is being signed by, again, an appointee of the governor of the state of Wisconsin. Totally different. I mean, an appointee is also, it's important to be clear, because we've had some comments about that. That's absolutely different than someone who has the job in the civil service system. This is a political appointment, as we say, meaning they could have been qualified or they could have been, lunch buddies with the governor, or who knows. There isn't a qualification test for a political appointment. And as they say, they work at the pleasure of the governor, meaning they can be removed for no reason. So that is one of the reasons why here, the question about, let's say, bias, that's the official word here for, is there an impermissible, we're going to use the word bias, but that's self-defining here. Is there an impermissible factor which alters, that we would expect, alters a judge's, for lack of a better word, ability to make a decision? That's what we're talking about, okay? So there are some factors that throughout at least common law history, going back to England, at least 500 years has been recognized, probably in Roman law as well, is going to be my guess, as creating bias. So a direct relative is an example of creating bias. Pecuniary bias, like you're getting paid, like your boss, for example, that you're assumed to have a bias because who wants to lose their living? So those are two examples where you don't have to go and find an actual, hey, the boss told the subordinate, go vote in my favor. We're just going, or the husband told the wife, hey, you need to vote for me. We're just going to assume that there's this bias there because of the way that we know that humans act. Okay? So let's keep that in mind. I wrote this on June 6th of this year, so not that long ago. And here's my introduction. This case was marred from the beginning by a secret conflict never disclosed to the complainant. This case was further marred by secret law never disclosed to the complainant. Nevertheless, the complainant submits the following brief under extreme protest and reserving all rights to further respond when and if necessary, due to the failure of the tribunal and the state to disclose that the Secretary of the Department of Workforce Development is a discriminator and therefore conflicted. These added injustices do not change the fact that the Department of Corrections discriminated against the complainant by altering her work conditions and treating her less favorably than other similarly situated employees, including wardens. These added injustices do not change the fact that the Department of Corrections terminated the complainant by creating a hostile work environment that any reasonable employee would see no alternative but to resign in order to protect their benefits and to end the harassment. So, that's my opening there. Critique-wise, I would say it was a little bombastic. This is something I've never heard of before, so I think that was the whole point of being bomb. I mean, how often have you heard of the judge's boss being one of the bad actors? And I think we've all seen that testimony, and we've seen the look on the judges and other people's faces when they're talking about Amy Pechacek and her involvement in Novak, and Novak's, in fact, letter calling out Pechacek for being basically controlled by Carr. So that being no different. That's problematic, to say the least. To say the least. Okay. So let's keep going here. I'm sorry I don't have the document to scroll down or whatever, and it's my own document. Of course, I could create a PDF, but here we are. Okay. The state of Wisconsin's hearing examiner heard testimony and admitted the state of Wisconsin's exhibits demonstrated that the state of Wisconsin's Department of Workforce Development secretary designee participated in the discrimination against Warden Novak without disclosing that fact. Woo, baby. So that's something we do here. You can see these kind of headings. You put argument in the headings. They're supposed to be in sentence form. Sometimes this early in the brief, you've really got to, there's no introduction enough to understand what's going on. So you've got to put a pretty big paragraph in there in the guise of one sentence. All right. Here we go. So now we're going to get into some serious law here. This is all state of Wisconsin law. I'm generally going to lay out the cases here, why that's exciting, just in terms of, is this a Wisconsin Supreme Court case? Is this Wisconsin-specific law? Is this a federal Supreme Court case? What we're going to be talking about is due process. So those are constitutional guarantees. Wisconsin has a constitution. The federal government has a constitution. They're slightly different. Okay? Sometimes the Wisconsin Constitution is guided by the federal Constitution. So sometimes if Wisconsin says, this is what the Wisconsin Constitution says, look, here's what the federal judges, Supreme Court says the federal Constitution says. Okay? That's one way that that's happening. So we're going to go back and forth on those issues because frequently what happens is there will be an issue in one of the 49 other states that arises, gets to the Supreme Court makes a decision, then people in Wisconsin are like, maybe it does mean that. So then they go and then to the Supreme Court, and then we got to decide what the issue is there. Because let's be clear, there's an order of operations here. The federal Supreme Court is superior to the Wisconsin Constitution in that if there's a conflict there, the federal Supreme Court is going to win. Okay? What the Wisconsin Constitution means, the Wisconsin Supreme Court gets to decide. What the federal Constitution means, the federal Supreme Court gets to decide. Okay, that's sort of the concept there. But ultimately, as we say, the U.S. Constitution is going to trump the Wisconsin Constitution because the U.S. is more powerful. There's because of federalism. We'll get into that more, but that's as much as we need to talk about now. Okay. Starting off with the quote. The right to an impartial judge is fundamental to our notion of due process. We've got a 2009 case, State versus Goodson. Only going to point out State versus somebody, that's a criminal case. Okay, so a lot of this is coming from criminal law. And then the federal case is Caperton versus Macy Coal Company, which is actually pretty recent, 2009. It is axiomatic that a fair trial in a fair tribunal is a basic requirement of due process. Okay, so if you're actually having a hearing, the hearing has to be fair. Okay, that means doesn't mean it has to be a full jury trial. Could just be a very simple hearing, an arraignment, okay? But in all stages of the case, any tribunal that you're going for, so tribunal here is a more generic term, so that could mean a court, but it could also mean an ALJ, okay? So an administrative law tribunal. Those things together, talking about, let's say, both of those tribunals, you can go in front of them and you can expect that the person who's making the complaint against you, or say the opposing party, is not going to be married to the person who is making the decision. You should be able to expect and demand, because it's a right, that the person who is making the decision, is their boss, is not on the other side. Or even had been. I mean, that's fair, okay? So that's a requirement, and again, it's a constitution. It's citing to the Constitution. And this is the standard for ALJ's fairness and honesty is the same as circuit court judges, okay? So now to tie that all together is, that's the law for judges. Well, what's the law for ALJs? We don't know. Well, there's a Wisconsin case that says it's the same standard. Believe me, it's come up before. All right. Tribunals are presumed to act fairly, impartially, and without bias, okay? And basically what that means is no other judge is going to take your word for one other judge being corrupt, okay? They're going to presume that they're following the law. What does it say? Fairly, impartially, and without bias. It's presumed. Okay, so that another way to put it is that puts the burden on you, who's making the allegation that they're biased, to show some sign of that fact. Okay, here it goes. To overcome that presumption, a party must show by a preponderance of the evidence, judicial bias, I should say, by a preponderance of the evidence. So what does that mean? That means you've got to show that there is either some kind of connection. I'm clearly getting ahead of myself, between the judge and one of the parties, for example. It's one of the ways to do it. If a party rebuts that presumption and shows a due process violation, the error is structural and not subject to a harmless error analysis. Okay, what's important about that? Harmless error means, well, we screwed up, but it's not fundamental, okay? And one way to look at that is, okay, the police used some evidence against you, withheld some evidence against you, and that totally violates your rights. No question about it, is what the judge might say in a case like this. But because we have your confession, we didn't need that other evidence to get you, and you're cooked anyway, so too bad. Okay? That's the harmless, it was harmless error, is what that means. I'm deeply skeptical of that theory. I do generally agree that there can be cases where the evidence is otherwise so overwhelming that a minor error is not going to cancel that out. I just don't think that we can very easily make that determination after the fact. I mean, who's to say that the guy wouldn't have confessed or would have confessed? There's a lot of who's to says. And that's why that always sort of bothers me. But it is the law. Okay, so party rebuts the presumption. So if you've got evidence that you can put out there saying that there is a due process violation, the thing about this kind of due process violation is everything's stopped. There's no harmless error. Even a tiny little bit of it, the whole thing's got a problem. Okay? That's pretty powerful. Here we go again. An unconstitutional failure to recuse constitutes a structural error. Okay? The presumption is not conclusive, and a showing of special facts and circumstances may demonstrate that the risk of unfairness in a particular case is intolerably high. All right, that's another one. An unacceptable bias, which basically, again, that's another way of putting that standard of bias, okay? So there is actual bias, is what we're talking about here. So that is, your sister is the victim, okay? Your brother is the plaintiff, okay? That's obvious, concrete, per se, that kind of bias. But then there's other kind of bias. So, for example, let's say you've got evidence of money changing hands. That's conclusive evidence of bias from one party to another to the judge, and you got a problem. Or let's say you've got an example of an ex parte. That means a conversation between one of the parties and the judge, and then the judge makes a ruling based on just that evidence alone. And I think we've got an example of that we'll be happy to share with you later. What happens then, right? So that's the key issue is there's a big problem because ultimately they have it's unacceptable, and you've got distinct evidence of that, okay? Now, there's a whole separate category, which is called an unacceptable risk of violence, okay? So, and we'll put that out. So there's statutory or common law, that's automatic disqualification. That's what we were just talking about. So common law or some statute or some other operation of law, and there's a statute that says the judge's brother can't be in the case. I mean, it doesn't put it quite those words, but that's a law, okay? So again, if you've got a law that says this is biased, then you can automatically overcome the presumption of bias by saying, bam, look, falls into that category. It's pretty narrow. And there's going to be a lot of opportunity for bias that are outside of that, okay? Here's the case that sort of exemplifies the second category, which is a 14th Amendment impermissible bias, okay? And the way that they phrase that here is, in Wisconsin, is a serious risk of actual bias based on objective and reasonable perceptions. Boy, is that a mouthful, okay? But that really is narrowing the concept, okay? Because let's just start out with this concept here, a risk of actual bias. Let's see, if you just use that phrase there, that is pretty broad, okay? Meaning a risk of actual bias. So the judge and the parties were at the country club, or one of the, and the defendant were at the country club, and they sat 2 tables away, okay? Well, part of that goes back to the assumption that the judge is not corrupt, and so we're going to assume that they didn't have, just because they were there. And there's plenty of cases where people say, hey, the judge and one of the attorneys are in the same bar association, or they whatever, okay? Or even they go fishing together, okay? That might not even be close to enough of a serious risk, okay? Now, the defining case for this sort of phrase here in Wisconsin facts of this. The judge is going on the Facebook page of one of the parties. He becomes a friend. That's how they get him. And he is looking at the Facebook posts of one of the parties, and the party is commenting about the case. So the problem is that there is a serious risk there that the judge is being influenced by one of the parties, okay? I shouldn't use the word serious risk, but there is a high probability that the judge is being influenced by one of the parties because they're hearing evidence, and there's undisputed fact there that they're hearing evidence from one of the parties that is not being able to be rebutted by the other party because they don't even know that the judge is observing it, okay? So that's sort of one of the reasons why we tell a jury not to go out and get information outside there. The same thing would, of course, apply to judges. So that's one of the problems there, of course, is because he's Facebook friended her that they were able to have the receipts, as they say. So that's this impermissible, a serious risk of actual bias based on objective and reasonable principles. Okay, objective. That is based on objective and reasonable principles. Okay, to take that phrase out, there's basically objective standard, subjective standard, okay? In employment law, that would say, and which we're talking about with the Novak case, is this serious enough? I know you feel, subjective would be, you feel that the behavior was outrageous to make you resign, okay? The question really is it objective, meaning does an outside observer, and what that's really going to mean is does the judge think that it's enough to have you resign? So that's way higher standard, obviously, okay? And because I want to point out, too, subjective is the personal standard, Now, the way they phrase objective is it's supposed to be, an outside observer, but in fact, it's that judge, just to be clear about what that really means, okay? And reasonable, so that's that judge, that's what the subjective part, and reasonable means what the judge thinks a regular a person of average normal intelligence would assume that would mean, okay? So a way to phrase that is it doesn't pass the smell test. But you also have to understand that there's going to be deep-seated bias even in this phrase, because of course the person who is judging the judge is going to be another judge. So I think we have to accept that there's going to be bias automatically in that kind of equation. So we're just trying to hear what we're doing. What I was just describing to you is the standard. That's basically what that is. The standard for impermissible bias in a Wisconsin case. Okay. So how do you show that? Well, one of the things you need to analyze when you're trying to show that is who do I have to show it to? So if you're showing it to your neighbor or your mom, that's going to be a totally different standard of what you need to show, even if it's the same words, same actual standard in there. You're going to have to prove more when you're proving it to a judge who's judging another judge. Okay. Cases in which the tribunal has a pecuniary interest in the outcome, in which the tribunal has been the target of personal abuse or criticism from a party before him, are situations where the probability of actual bias on the part of the judge or decision maker is too high to be constitutionally tolerable under due process of law. Okay? This is going to cite a bunch of Supreme Court cases, but I'm going to mention them because I think they're all very interesting to look at. Withrow v. Larkin, very interesting. Taylor v. Hayes, another one. Mayberry versus Pennsylvania. And I think probably the most interesting one of all for this channel's purposes is Pickering versus Board of Education. That's where a teacher gets up at a public meeting and criticizes the board, and then they fire him. That's like the quintessence of what we do here, wouldn't you say? So, okay. That's why. Pickering, cited by the Supreme Court, equates personal abuse with democratic criticism. In that case, Mr. Pickering, an employee of a school district, made a public statement. It's almost as if I wrote this. Critical of the government, the school board, who fired him in retaliation. Pickering famously found that a public employee has free speech rights. Pickering also argued that the board, as a target of free speech criticisms, could not sit as a tribunal over the decision to terminate him with due process. Pecuniary interests do not necessarily mean that the tribunal has a direct financial interest in an outcome, and the court recognizes more indirect interests, such as, for example, departmental budgets. And that's a mayor who was held to be an invalid judge, where the fines went directly into the police department budget, which he oversaw. So that's a situation where the mayor is, I guess, the justice of the peace, something like that, okay? The fines for the, traffic court are going straight into the police department's budget, and that's a conflict of interest. Okay. Determining whether an administrative adjudicator has, sorry, I'm going way further there. Okay. Lurk has not hesitated to find impermissible bias where the administrative law judge, 1, asked the complainant at the commencement of the hearing whether she carried a gun, and 2, made negative comments about the quality of the complainant's representation. There was an appearance of bias serious enough to warrant disqualification. That's Phillips versus Milwaukee County Medical Complex. It's a Lurk decision going back to 89. A movement may show that the adjudicator had become psychologically wedded to a predetermined disposal of the case. Yeah, they may do that. Determining whether an administrative adjudicator has prejudged a matter requires an examination of the facts of the individual case. A clear statement suggesting that a decision has already been reached or prejudged suffice to invalidate a decision. There's Maris versus City of Cedarburg. That's 93. Circumstances which lead to a high probability of bias may be sufficient to establish violation of due process, even though there is no actual bias is revealed in the record. And that's Burton versus U.S. Government Services, Lurk, 2010. The reason I cite that one is because that's Alice DeLaO, let's say, extravaganza. She had a lot, I believe, to do with that one. I could be wrong. I sometimes get Burton and Brown confused. But those are the two cases there in which judges who, administrative law judges, basically just did whatever they want to get rid of the case. I don't know if that sounds familiar to anybody else. And some poor employee had to go all the way to the appeals court to get that settled. And, of course, there was no consequences for the ALJs because that might help to solve the problem, so which didn't happen. So that's that. Okay. So circumstances which, even no actual bias. So circumstances like, for example, the boss being a bad actor and you don't mention it. And see, that's also a really big problem here is because they don't mention it and we spend the whole 7 days of the hearing, which is something that Judge DeLaO knew on the first day, okay? It really did not occur to me that the secretary, administrative deputy secretary, was now the secretary of the Department of Workforce Development. It did not occur to me until after we did the whole hearing. Occurred to ALJ DeLaO. No doubt about that. You can see it in her face and otherwise. All right. The respondent produced an exhibit, R27, an email dated May 3rd of 2020 from Sue Novak to Secretary Kevin Carr, which was admitted without objection. Email chain, Kevin Carr receives a complaint and an additional information from Sue Novak about the information that she provided to Doug Percy prior to the escape. Secretary Carr denies learning about this information. She does mention that she contacted Doug Percy 1 week prior to the escape to discuss the kitchen worker, okay? And that's from Secretary Carr on day one. He says that. Well, we've got this email here from Sue Novak, May 3rd. Hello, Secretary Carr. I am well aware that there is an ongoing investigation regarding CCI and the escape. I do not want to impede the investigation in any fashion, but I felt there was a few things that you needed to know. I was interviewed by Internal Affairs as a witness on 2 separate occasions. I was asked very limited and specific questions. I did not elaborate on other points, but I am hoping that there will be a time when I can do so. The first thing I wanted to mention is that I called Doug Percy prior to the escape. And so we had all that information. We talked about all that. We talked about Secretary Carr. And remember, his testimony was somebody told him that Doug Percy didn't do anything wrong, but I didn't remember who it was. I just want to point out that I remember that statement from his testimony when we did it over Zoom like a year ago. But they can't remember who told them that? I mean, okay. So Secretary Pechacek acted as a conduit between the internal affairs and participated in decision-making with the division administrator and is frequently referred to both by name but also by the Secretary's office. Right? We heard that. How many times did Mac DeFessa say she was in consultation with the Secretary's office? We didn't know what that meant. Very often it meant Pechacek. The Secretary also witnessed the key incidents of sex discrimination. This is Secretary Pechacek, where Secretary and Carr and Pechacek described Novak as emotional at a meeting with then Deputy Secretary Pechacek. Almost in tears, or rather emotional, did you discuss the meeting with anybody else again? And I'm going to object because we're way beyond this. Is what's his face? Eric coming in. I'm going to object. And then, Judge DeLaO says, I'm going to allow it because this is a decision maker. Go ahead. I don't recall having any conversations with anyone after that conversation, but I believe it took place in my conference room with other people present, and I believe those present other people were probably Deputy Secretary Pechacek. That's Carr's testimony. The tribunal, whose ultimate supervisor is Secretary Pechacek, made no mention of that fact whatsoever, despite the numerous times that Mitch Pechacek was named either by witness or in exhibit. I think what I did here, yeah, okay. I can see from the way that I'm writing this here that I'm displeased. C, for example, Complaints Exhibit 10. Okay, here we go. With information provided above, it appears that this is what Novak speaking, and being singled out not only as the first female warden of a maximum custody male institution in the approximately 170-year history of the Wisconsin DOC, but also as a female. I am neither being treated fairly nor am I being treated consistently when a serious event occurs compared to male wardens. Of even greater injustice to my 30-year career, it appears that Secretary Carr has placed himself in a position of answering to an advocacy group, and I will not receive fair due process. It appears this investigation of a serious event, unlike the one cited above involving male wardens, is a method for Secretary Carr to search for a possible work rule to give him the ability to meet the demands of an advocacy group and discipline or fire her. Remember how much trouble we had just getting that information on the record at all. We had to do it like 3 or 4 different times because DeLaO would not allow us to discuss that. This is the newsletter which talks about their conversation with Secretary Carr and mentions his conversations. She's saying that's impermissible hearsay, which again, kind of shocking to me. All right. It appears that discipline or fire her at the expense of my reputation as a dedicated and loyal employee of the department for 30 years. I had no contact with Sue Novak when she wrote that. If she wrote it on herself, if she had any help, that is a great example of what you should be writing before you're terminated or constructively discharged. A great example. I have provided information showing that the gender-based inequality of my treatment as a female and the targeted comments of the DOC Secretary Carr concerning me to an advocacy group with the Assistant Deputy Secretary Carpenter and DAI Administrator Pechacek in attendance. Given his targeted comments towards me, I believe Mr. Carr has taken a personal involvement in this matter and ethically should have recused himself and all those within his jurisdiction of the authority from the decision making concerning me. Rather, Mr. Carr has placed his Deputy Secretary Pechacek, his next in command, as the hiring authority of this investigation and in position to oppose any possible discipline. Given the close working relationship between the DOC Secretary and the Deputy Secretary, it is unlikely I will be afforded a fair and unbiased review of this investigation. Not only did she say this to Secretary Carr prior to her separation, we put this on the record in this case. And my reading of what happened from all of the testimony is exactly what she's describing here. Exactly what she's describing here. Here's some quotes. Did you have any conversations with Doug Percy's knowledge of the kitchen worker let's say concerning the kitchen worker prior to the escape. And of course, there's going to be objection. I'm going to object. This is actually answered several times at this point. I'm going to go ahead. Sorry, this is a YouTube transcript here. Okay. So I may have had a conversation with Christy Preston and maybe my executive staff about the role that this kitchen worker played in the escape, and whether or not any supervisors, including Doug or Makta, may have had some responsibility for that, who may have those conversations maybe with, just said my deputies, Secretary Pechacek and at that time Shannon, and that's the same deputies. Oh, I'm sorry, are you finished, sir? Yeah, no, go ahead. Oh, so that's the same deputy secretary that forward your email containing Sue Novak's statement from Doug Percy to Chrissy Preston of Internal Affairs, right? That's correct. Okay, excuse me, my number 2 person. So we heard that testimony on day 1. Alice DeLaO heard that testimony on day 1. Did anybody hear Alice DeLaO mention that this is her boss? Okay. Let's look at this here. This is the hearing notice right there, and it says, Department of Workforce Development, Tony Evers, Governor, Amy Pechacek, Secretary Designee. Okay, that's the notice for the hearing. Secretary Pechacek, whatever, name appears in the hearing notice and all other correspondence from the department. This is the appearance of bias where the ultimate decision maker, that is the department, is supervised by someone who is in turn supervised by the bad actor, Secretary Kevin Carr, and herself directly participated in the discriminatory investigation of Warden Sue Novak. And again, that was never divulged to the complainant at any time. Now, I want to tell you that we've made a complaint all throughout, and especially to Secretary Pechacek herself. She has never responded. So we've got some, we're going to keep going, but just to be clear, Secretary Pechacek has never, ever responded to these accusations. She's had her subordinates do that for her. So I don't hold anybody who, a government employee who refuses to respond to accusations of bias, I don't hold them in high regard. This is precisely the appearance of bias. How is Warden or any other complainant before this department supposed to feel like they have had a fair shot when the decision maker is reviewing her own decisions? This is not justice, this is bias. The state of Wisconsin is represented by 2 parties in this forum, neither of which raised Secretary's conflict during the hearing. The hearing examiner was visibly started upon hearing the name of her boss during the testimony, and at no time did she raise the issue or disclose the conflict. And I think we all saw that. In similar vein, the state of Wisconsin and the guys at the Department of Correction was also aware that the former secretary from the department is now the secretary of the Department of Workforce Development. They didn't tell me either. The tribunal and the respondent should have disclosed the conflict. Their failure to do so prejudiced the tribunal and tainted the whole tenor and tone of the hearing because of the actual and perceived bias. The remedy here is a new hearing at the DOC's expense and a hearing examiner not supervised and not ultimately decided by the bad actor. I also note that the complainant wasted time identifying the conflict that should have been disclosed by the state of Wisconsin, but also spent time that otherwise would have been availed responding to the merits of this claim. Here again, just like the state of Wisconsin refuses to produce the law on constructive discharge, and is mentioned and incorporated by reference in our motion on June 5th regarding the Lurch Tribunal's refusal to produce case law, including those relevant to the case, namely on constructive discharge. We'll save that for another day. That's going to lead into section 2 here. So stick with us. We'll keep you informed. But that really is the case against Alice DeLaO and Secretary Pechacek for the actual bias here that is being displayed against Sue Novak. So again, stick with us. Thank you all. We'll keep you informed.